Morning, a very warm welcome to you today to this, our first in a series of webinars and events looking at the effective use of NEC contracts. And today's topic is a comparison between the NEC and JCT. My name is Robert Tunningley. I'm a partner in the construction and engineering team at Urban Mitchell, and we are a team of 14 based all up and down the UK. I'm delighted to be joined today by two of my colleagues, Timothy Willis and Natalie Kane. Tim is a senior associate on the contentious side of our team, and we are lucky to have Tim as he is actually an accredited trainer of the use of the NEC contract. So he's well versed in looking at disputes, interpretation, and negotiation of the NEC form. And Natalie Kane, an associate on the non-contentious part of our team. Natalie tends to act for developers, contractors, funders, etc. on UK-based projects. So it'd be perhaps no surprise that Tim will be concentrating on the NEC while Natalie concentrates on the JCT during today's seminar. It is being recorded today, and if you do have any questions as you go along, please feel free to put them into the Q&A. If we don't get a chance to answer them today, then please feel free to drop either myself or Tim or Natalie a line afterwards, and our details there are on the slides. So just before we get into the seminar, then a little bit of introduction about what we do as a team. We act for all members of the construction industry, whether it be developers, contractors, subcontractors or funders, increasingly insolvency practitioners too. And we advise on all aspects of construction and engineering work, whether that be front-end work or back-end work, and in particular as well, what I like to call the contract advisory piece. So whether something's not quite a dispute yet, but you may need a legal opinion on what your rights and remedies are in the contract if a dispute it looks like it's on the horizon. We offer practical support to meet our clients' needs, and we always try and provide that advice with clients' commercial objectives in mind. We have extensive knowledge and experience on a number of different matters in construction engineering work, but particularly we provide a lot of advice on procurement strategies, not just on NEC and JCT, but we are also well versed in all the other standard form contracts such as FIDIC and ICME. We have an enviable reputation, I think, in the disputes sector. So not only are we able to run multiple adjudications all at once, we can also run international arbitrations and take cases all the way up to the TCC. Over the last few years, we have carved out a niche as well in terms of building safety. And by that, I don't just mean advice in terms of the new regulations in the Building Safety Act, but helping our clients where there are fire and structural issues which need rectifying in higher-rise buildings, and also advising on the cladding safety scheme and various developer pledges, etc., to help make buildings safer. And as I alluded to earlier, we're doing a lot of work in the insolvency space too with our insolvency colleagues. As probably most of us will know on this call, unfortunately, in the construction industry, insolvency is still very, very high and the highest of any industry in the UK. Just before we then start, also just to give a little bit of information about what we are intending to do on this series of webinars and events. Obviously, this is the first one, and we'll be holding a number of these across the next year. We will concentrate on the NEC4 engineering contract, but the principles of the NEC contract mainly apply to all the way across the family. There will be details coming your way about the upcoming seminars, and there's a QR code at the end of this presentation where you can find further information. But for the next one is on the 20th of January, and that will deal with the NEC building blocks, depending on how the procurement routes available are to the client, etc., whether you use frameworks or two-stage tenders. It will look at which contract is appropriate for the chosen route. They won't all be webinars either, so we will be doing more towards the end of the series in person. So hopefully we'll get to see a number of you on this webinar today. Okay, then, so moving on to today, on the agenda, what we will do is we'll summarize the main objectives of both the NEC and the JCT and their approach to risk there being a key word, and I'm sure Tim will probably use that quite a lot in respect of the NEC contracts, and we'll compare how they deal with a number of the different issues. Finally, just at the end, what we'll do is kind of give a brief overview as to how we tend to see these contracts amended. NEC and JCT obviously don't like you amending them too much, but we'll give a sort of flavour about why we amend those contracts and the types of things that we like to do, particularly when we're acting client side. So with that in mind, then I'd like to pass that over to Tim and Natalie, who will take you through most of the rest of the presentation.
Thanks very much, Robert. Good morning, everyone. So I'll be taking us through the NEC contract, and what we're looking at then is a family of contracts published by the Institution of Civil Engineers underneath a subdivision of theirs, Thomas Telford, but the branding you'll see is NEC, so we refer to them as NEC contracts. First edition of these back in 1991, then a big rewrite in the third edition in 2005, which was then reprinted again with significant changes in 2013. And then now the fourth edition is the one we're on, published in 2017. And that has then had some reprints to it as well. So the most recent set of amendments, as it were, to this are January 2023. So it's a suite of contracts which has evolved and is constantly updated. The reason for ICE choosing to publish this was because of shortcomings that were considered to exist in the traditional forms of contract, both published by ICE, but other standardized forms of contract. One of the things that the ICE wanted to address was the fact that we tend to use many different standard forms within a particular project, depending on who we're appointing in the supply chain. And so the intention was to come up with a family of contracts so that a procurement team would be able to become used to structures in terms of preparation of documentation and structures in terms of allocation of risk and management of risk across the web of the supply chain. Now that as an aspiration is obviously something which then bumps up against the hard realities of what the supply chain and what the market will respond to. So although these contracts all web together and are potentially back to back, one of the things we'll see is that in different parts of the supply chain, the attitude to risk is different, and therefore that requires that sometimes that original aspiration is amended to reflect maybe the difference between a tier one contractor and the subcontractor in terms of risk allocation, and also maybe the difference between the way consultants and contractors are treated in terms of risk allocation. But whatever you're dealing with and whether you're choosing to amend them or not, you start from very similar building blocks, and that makes things easy for supply chain to train teams and also for procurement teams to understand the documentation. The intention too was that this family should be capable of use in a broad context, so it could be used anywhere depending upon the jurisdiction in which was being used. Then you may need to make some changes so we can use them internationally. And there's been considerable success in terms of their use as both a domestic and an international contract. The focus of these contracts then is very much that although in contract terms in a transaction we might talk about allocating risk, and we might in terms of liability suggest that one party holds the risk, the reality in a construction project is that if risk materializes, it will impact on everyone, even those people who feel that they've been insulated to some extent by the contract documentation will still have to deal with the practical consequences of the risk that's materialized, and litigation or liability routes to manage that are not often seen as a particularly satisfactory way of dealing with that. So the approach is really then to try and maximize the opportunity that people have to collaborate and manage risk. And that is a different mindset. It means that the client and the supply chain have to take a more active approach to risk management. So that's central to the processes in the contract, and to some extent distinguishes them in terms of the level of those processes and the detail of those processes when compared to some of the other standard forms. And we'll come to those in a bit more detail. So I think over to you, Natalie.
Thank you, Tim. Okay, so a bit of background from a JCT perspective then. So the Joint Contracts Tribunal, JCT, has been established since 1931 and offers a full suite of standard form contracts which can be used by everyone from large public bodies or private corporations to individual homeowners. They provide forms of ancillary documents such as subcontracts, collateral warranties and bonds. They also provide extensive guidance notes to accompany all of their contracts. They're currently the most widely used forms of contract, and then because of that, the industry is more familiar with their terms and they are commonly accepted by third parties such as funders. The contracts cover most common procurement methods of traditional, design and build, and management. They can be used where the contractor is not designing the works at all, where they are designing part of them, and where they are taking on responsibility for all of the design. And that design might include design by third parties such as architects or engineers. They can be used where there is a fixed fee for the whole project or where costs are still to be determined. Some of the forms are especially designed for when works need to be started at pace. There are simpler forms and more complex forms for larger projects and more detailed projects. The management range of contracts are for use where the management contractor manages a series of trade contractors on behalf of the employer, rather than carrying out any construction works themselves. The design and build contract is the most commonly used form of JCT and is normally used on larger, more complex projects. It's based on a lump sum price, which can only be adjusted on the terms contained within the contract. The contractor carries out both the design and the construction of the works. New editions of the JCT contracts were introduced just last year, and they have been updated in respect of legislative changes, most notably the Building Safety Act 2022, and they have also made tweaks in relation to collaborative working, sustainable development, and environmental factors. We now know that the previous 2016 versions will no longer be available as of 31st of March 2026. So we all need to become familiar with the 2024 versions now. I'll hand back over to Tim in relation to approach.
Next slide, please. So the NEC family of contracts then covers professional appointment documents for appointing consultants or advisors, a broad range of works contracts, which would be used for capital projects, supply contracts where the client simply wanted to procure materials or purchase products, term contracts where the client wants a contractor to provide a service or manage a facility over a term rather than a specific project. An alliance contract where there may be some very complex projects where simply trying to work with one tier one contractor who's taking full responsibility for delivery is impracticable, and you need to have a series of really quite large players who are working together in a collaborative context to deliver something which perhaps either from the client's perspective or from the tier one contractor's perspective would be very challenging to deliver in a simple structure. And then framework contracts, which we often see used to put together supply chains and to bundle projects together so that we don't repeat procurement at an extensive level, and allow also supply chains and clients to develop methods of working and practices common across their businesses, across their projects, so that you get those efficiencies of repetition and those kind of deeper relationships which are possible if in fact you have a framework across a reasonable period of time in which the contractors and the client and the supply chain are consistently working. The forms of contract are published both in what's called the complex version or the simple contract. So the short forms of contract are published for projects where the degree of risk management required is considerably less. And therefore some of the procedures and the resource that you would normally attach to risk management are stripped out of the contracts. That does reduce them in terms of the size of the printing and so on, which is always encouraging, but it also means that the resource that a client needs to consider applying to the contract is less, and often those contracts can be managed directly as a relationship between the client and the contractor. In the complex forms, the full forms, those tend to be managed by a relationship between a project manager or a service manager who's appointed by the client, and then it's the service manager or the project manager who has the interface with the contractor or the service provider and will operate the procedures with the client working alongside them and consulted consistently in terms of decisions, management of risk and so on, but the process is being operated through the service manager or provider. The NEC contracts don't sort of just talk about particular procurement routes like design and build or management contracting, but within the options available, you can adopt the contracts to make them design and build by the way that you deal with your content, which is called scope, or the way in which you deal with the payment options. And that means that what we're tending to do is use flexibility within the documents themselves to approach different procurement solutions. And the contracts also start with a set of core clauses, the base conditions, but then on top of that the client then makes certain selections, which include standard secondary options, which allow further customization of the project. And that could be anything from deciding that you need sectional completion, or that you want to have liquidated damages for delay, or that you require an ultimate parent company guarantee to be provided. But those secondary options are all available. So what you get used to is a structure where a client makes a series of selections based upon building blocks which become very familiar, and that allows customization to the particular project. And the intention then is that if these structures are similar, then the procurement teams get very used to how to package these together. And it is expected that the client and the consultants will be very significantly involved in those choices. Back to Natalie.
So we've just put on the screen here a list of main JCT contracts that are available and grouped them by the different procurement methods. And so a traditional procurement method would be where the employer engages a contractor to carry out the construction works in accordance with designs produced by the employer's professional teams. So, for example, architects and mechanical and structural engineers and various other consultants. And then in design and build procurement, the contractor takes on responsibility for some or all of the design. And then in management procurement, the employer will usually engage its own professional team to design the project, but a management contractor will then manage and coordinate the construction works and engage the individual works contractors. And then on the next slide, we have just listed a few of the other documents that are also available: the repair and maintenance contract for just simple repairs, homeowner contracts, and as mentioned earlier, forms of subcontracts and collateral warranties. Back to you, Tim.
So the NEC contract contains procedures within it to manage risk, and that comes back to this essential point that once risk has materialized, it impacts the whole of the project, irrespective of what the contract documentation says about liability for that. And therefore, the contract takes the view that what we want to do is give everyone the best tools to be able to manage risk, and that then leaves the client with a choice when risk is in prospect. That choice is always against the background of who does hold the risk. So the analysis still happens as to, if we do nothing, what are the consequences? Is the consequence that my project will be delayed, but I will take delay damages? Or is the consequence that the project will be delayed and I will be paying additional money to the contractor and extending the completion date? So there is always a commercial background to this, but the point is to give the client the opportunity to make a choice as to whether or not they wish to do something differently. And a client may wish to do something differently, or in collaboration with the supply chain, it may be able to come up with solutions that will mitigate that risk. And so that requires a very active risk management mindset from the client. And it also requires that we have the processes in place, so that the processes that we'll look at in more detail in later events are essentially detailed programming during the course of the project, so that we have a very clear understanding of who's doing what, when, and the interfaces and the impact in terms of critical path and delay, if the various contributions of people don't happen at the point where we expect them to. And that programming also is used to allow us to predict what the implications will be in terms of the planned completion date, as shown by our program. Into that initial sort of framework, what we do is advise of anything through the early warning procedures, where we think that there could be an impact that would delay completion or increase the prices or impair the performance of the works in use. And those early warnings then, those are given at the point where something could impact on those. So that's just looking ahead. It's not once something is going to happen or is probably going to happen. It's looking ahead, something might happen. And it gives us the opportunity to consider how we're going to respond to that. And that means that we need the contractor, the project manager, usually on behalf of the client, and the supply chain to be warning of these things. And the use of subcontracts in the NEC family, which contain these same processes, again, should mean that we get that information flow coming through. What it means, though, is that we can't really allow people to behave in a way whereby they will tell us what it's convenient for them to tell us. And I think we also have to be realistic about the commercial pressures that people are under. So if we simply allow people to give us the information they feel like giving us, then we may not get the information we need. So it probably needs that thinking about the records and the information transfer at the point you enter into the contract, so that you're clear that you get the records you need from the people at the time you need them, in order to be able to understand risk and make decisions based on real data, not just fanciful suggestions from a contractor that we're going to complete on time, when in fact, if you look at the records, that's clearly not going to be the case. And NEC departs significantly from JCT in this respect, in that it's very much more demanding in terms of the programming, and it looks at adjusting on the basis of a prediction rather than a retrospective analysis of what happened after the event. Over to you, Natalie.
Thanks, Tim. Okay, so the general approach of the JCT contracts is to establish the responsibilities and obligations of all the parties within the construction process at the outset. so that it's clear what is to be done, by who, by when, and for how much. The forms set out the risks assumed by both the parties. They're generally considered to be more contractor friendly in their standard forms, and so are often amended quite heavily to be more favourable to the employer, who is generally in the stronger bargaining position. Allocating and agreeing the risk levels between the parties can result in complex negotiation processes. However, once agreed, they do offer certainty and consistency to the parties. The contracts themselves are formed of the agreement details containing the party details, the recitals which set out the types of works that are to be undertaken and what further documents make up the contract, the articles which detail the contract price and other relevant parties. You then have the contract particulars, which set out all the project-specific information, such as date for completion, the amount of liquidated damages, and the insurances that are needed to be held during the course of the contract works. The conditions then set out in detail the terms of the contract and are where the bulk of the negotiation will be. And set out the risk allocation between the parties. And finally, there are a number of schedules at the end of the contracts which allow for various additional terms to be included if required on a case-by-case basis. Tim.
Next slide, please. So in the NEC contracts, the contract does not transfer as much risk to the contractor as in the context of the JCT contracts. And the sort of risks which are not transferred are really to do with documentation, firstly. The client does take responsibility for the adequacy of the documentation it's produced. So if you produce poor specifications or poor content in terms of how the contract has got to manage the site or deal with access or completion, those sorts of issues, then if the contractor can suggest that the documentation is unclear or is missing information, then generally that would be a basis upon which they can come back and say, well, you haven't given the information we need, and therefore you must issue that information. And if that is the case, then the client is usually adding to the scope, and that triggers a compensation event because that's a change to the scope from that which was originally issued at the point the contract was entered into. Similarly, if the information is inconsistent, then the contractor can require that that inconsistency is resolved. And again, usually the inconsistency, if it sits within the client information, is resolved in favour of the contractor, and the contractor is deemed to have interpreted the information on the basis most favourable to it. So therefore, if the client says, actually, I want the more onerous interpretation, then that's treated as a change in scope again, which would give rise to additional time and money. The NEC contract has a specific clause around physical conditions. The physical conditions clause is not a hardwired position. What it says is that the contractor can make a claim for unforeseen physical conditions, but then what we mean by unforeseen depends upon the information which the client provides to the contractors at the point they enter into the contract. Part of that information is what the contract refers to as site information. And what that is information which the client holds, but you would not expect an experienced contractor to be able to obtain simply from their own tender inquiries, or to be available from a visual inspection of the site. So it's information which is, in a sense, peculiar to the client and the client's knowledge. If we include that in our tender documents, then that moves the boundaries so that the contractors then are taken to have taken that into account when deciding what's unforeseen. If we don't include it, then the tenderers are taken not to be aware of it. And again, that's a slightly different approach to some commercial contracts that will seek to transfer all risk to a contractor. The other area where the NEC contract is perhaps more explicit is that the procedures in the contract are operated by the project manager and then to some extent by someone called the supervisor who deals with quality and defects. And if those people who are appointed by the client don't operate the contract procedures properly, then it's the client who will pick up responsibility for any time or money implications that arise from their failure to do so. The contract does assume also that there are things that the client is responsible for beyond the scope, that there may be things the client has to provide or things the client has to do or work that the client suggests that it is carrying out or others will carry out on its behalf. And so what we see is that the project is seen as a web of responsibilities. Each party to some extent taking responsibility for those things for which it's responsible and therefore not simply trying to transfer all risk to the contractor. Natalie.
Okay, so from a JCT perspective, risk assessments are undertaken before the contract is entered into and risk events are allocated to each party. The standard forms allocate various risks to both parties, but during contract negotiations, these are often swung more towards the contractor. This is particularly the case where the contractor is responsible for all or perhaps a large portion of the design. There's no scope for the risk allocation to be adjusted as the project goes on. These remain as agreed at the outset. Robert will go into a bit more detail about the amendments that are often made to risk allocation at the end of the webinar, but these would include things such as contractor taking on full responsibility for existing site conditions, having to comply with obligations under various third-party agreements, and being responsible for correcting defects within a certain time period. Although JCT contracts can be signed both underhand or as a deed, it is common for them to be signed as a deed, as this provides the employer with a 12-year limitation period in which they can bring claims against the contractor, as opposed to 6 years if signed simply underhand. Passing most of the risk to the contractor will give more certainty and security to an employer, but can obviously result in higher prices from contractors or deterring contractors from even accepting the project at all. So a balance needs to be found. In a traditional contract type, we have a contract administrator, and in a design and build contract, there is an employer's agent. Both of these roles carry out a large number of functions under the contract on behalf of the employer. For example, overseeing the works, checking the progress of the works, administering the payment processes, and certifying practical completion. JCT contracts are therefore great for use where the employer perhaps is less experienced in construction and wants the contractor to take on more of the responsibility, or where the employer generally just wants more control and certainty. Back to you, Tim.
So the NEC contracts manage the adjustment of time and money through a mechanism called compensation events. And there are a significant number of compensation events. What they tend to relate to is either the failure of the client to do something the client was required to do, failure by the project manager or the supervisor to do what they were required to do, or unforeseen or unusual circumstances that may impact upon the works. The compensation events all entitle the contractor to both time and money. There are no neutral events, as you find in some contracts. And there's a general caveat that if the event is actually the fault of the contractor, then notwithstanding that it might fall within the wording of a compensation event, then it's not treated as a compensation event. The compensation event mechanism then requires a notification process in order for it to be operated. generally speaking, things which the project manager does, i.e. issuing instructions, it will be the project manager who will notify at the point they're doing that and starts the process. But for the things which the contractor's aware of impacting the works, like not being given access or the project manager failing to respond to something, then the onus is on the contractor to notify. And where the contractor has the onus to notify, they must notify within 8 weeks becoming aware of the event. And those timescales are treated as conditions precedent. So if you get into a dispute and you're the contractor and you miss the timescale, there's a high possibility that the tribunal will just say that you don't have any entitlement to adjustment of time or money. There's a link between the adjustment of time and money and the early warning process, in that if you didn't give the client the opportunity to manage risk when that opportunity was there, and subsequently it materializes, then as the contractor, you may not be fully compensated for the time and cost which you've incurred. You may simply be compensated to the extent which that cost would have arisen had you given the client the opportunity to mitigate and avoid the risk. Asti.
Okay, so under the JCT, the provision for extra time and money is critical to the risk management under these contracts. Rather than being one event like Tim has just discussed under NEC, the JCT splits out the events following which the contractor will be entitled to extra time or loss and expense. This is an area which is often amended in the contracts to reduce the availability of both. Under the JCT, they are known as relevant events, which allow for extra time, and relevant matters, which allow for extra money. Where a relevant event delays or is likely to delay the progress of the works or any section, the contractor is entitled to an adjustment of the completion date. If the contractor incurs or is likely to incur direct loss and/or expense because the regular progress of the works has been or is likely to be affected by a relevant matter, then the contractor is entitled to an adjustment of the contract sum. The contractor is to notify the contract administrator or the employer, depending on the type of contract, where either event has affected or is likely to affect the progress of the works or cause loss. The contractor must also provide evidence to support their claims. The contract administrator or the employer, as the case may be, then determines the effects of the events on the works, and as a result, the contractor's entitlement to either extra time and/or money. Although distinct from one another and with different mechanisms for claiming such provision, there is considerable overlap between the two. In the standard forms, all relevant matters are also relevant events, as these are employer risk events. However, there are additional relevant events which are not relevant matters. So for these, the contractor would only be entitled to time and not extra money. These extra relevant events cover neutral events such as adverse weather conditions, strikes, delay in the receipt of any necessary approvals, and force majeure. But even if one event does come under both, then the contractor will need to follow the two separate notification processes in order to claim for both extra time and extra money. Tim.
Next slide, please. So in the next two slides, we've listed the compensation events under the NEC4 contract, and I'm not going to try and go through those today because that will be the subject of a later event. But they are, as mentioned, relate really to failure by the project manager to do something, the client to do something, or something unforeseen or unusual that impacts on the work. Some of them also are tied back to what has been agreed in the scope or what has been agreed in the course of the program being accepted. And so there's quite a tight relationship between the contract documentation and the programming and the compensation event processes. That relationship also flows through into the mechanism for awarding additional time, which is to look at the accepted program and to see what is the impact in terms of delay to what's called planned completion, which is just the date of the last operation on the program being completed, and that will be on the end of our critical path. So it takes a sense a more scientific approach to the adjustments than a JCT contract that will just look at a fair and reasonable extension of time based upon someone's view of what the relationship is between the completion date and the work, rather than planned completion as shown on a program. Next slide, please. So this slide is just a continuation of that list of compensation events, and so some of them we'll find relate to the hardwired drafting in clause 60 of the contract, but there are others to which you can find because secondary options have been chosen, which have supplemented the hardwired drafting. So X 2.1 is change in law after the contract date. So that would only be a compensation event if the client had selected that in setting up the contract, and similarly with the other X clause references there. There's also flexibility in that the client can add additional compensation events in part of the documents called the contract data, which we'll look at in more detail when we're dealing with the building blocks of NEC contracts. But also clients will amend the standard drafting in the Z clauses section of the contract, either to add additional compensation events or to delete compensation events where they want to take that risk and move it back to the contractor. And so you'll see project-specific allocation of risk going on in addition to the standard structure. Over to you, Natalie.
I mean, as you had said before, the relevant events and relevant matters, we've put some examples here on the screen like you did with the NEC. I wasn't intending to run through these in any detail in the interest of time, but yeah, there's some examples of them, the main ones on the screen there for future reference. I think we're moving on to design now.
Okay. Yeah, so the slides will be available, so you'll be able to look at those in more detail at your leisure. Design. So the NEC contracts do not have a design and build form of contract, but what they allow the client to do is in drafting the scope documentation, which defines what the supply chain are doing, they can identify that the supply chain or the contractor will be responsible for design. How you do that is entirely up to a client in terms of how they draft that documentation. The actual conditions of contract don't make any assumptions beyond a general position that if you've not clearly allocated the design to the contractor, then the design will sit with the client. Once you have allocated design, and that could be either responsibility for completing the whole of the design beyond the stage which the client has taken it to, or it could be what we might call a design portion in a JCT context, where they just got responsibility for a discrete aspect of the work. They will take, in terms of a standard of responsibility, whatever is set by the applicable law. So what the design standard then will be determined by what we've said in the scope and the applicable law. In terms of workmanship then, it's important that clients draft scope in reasonable detail to set out the standards and the requirements they have. If they don't do that, they will fall back to the sort of general standards that you might get under the applicable law, but those are not the best place to start. In terms of design, The applicable law, if you say nothing else, would potentially place a fitness for purpose obligation on the contractor. Another aspect of the contract is that, again, looking at quality and so on, the testing and inspection regime needs to be fairly fully set out in the scope. And therefore, that's another thing which the client needs to think about when drafting the scope documents. Falling back onto implied terms can be problematic because there is potentially an entire agreement clause in the contract drafting, and therefore you'll get arguments about the extent to which implied terms will arise. The obligation to comply with the applicable law is an express term, so to the extent that under our law, fitness for purpose may well be the standard, then the position is going to be that if the contractor wants a lesser standard than fitness for purpose, then they will have to argue that the scope has clearly not required that, or they will have to rely upon a secondary option clause, X15, which expressly limits the contractor's liability for design to reasonable skill and care. And so it is customary, we will see in most tenders in this country then, that where the contractor is being given a design responsibility, then X15, the secondary option, will be included. And that clearly then prevents a fitness for purpose obligation from arising. You do sometimes see amendment around the wording for that. And in particular contexts where a fitness for purpose obligation is accepted within the industry, and perhaps where limitations of liability have negotiated around that, you will sometimes see a sort of a stronger fitness for purpose obligation undertaken. Natalie.
So as mentioned earlier, the JCT contracts have different forms depending on where the design responsibilities lie. Under traditional procurement, the contractor may have no responsibility for design or may design a portion of the works, whereas under design and build procurement, the contractor will usually be responsible for all or a large portion of the design. Under the JCT design and build contract, the employer sets out what they want from the project. These are known as the employer's requirements, and the contractor reviews these and responds with their contractor's proposals. The employer's requirements will usually contain design by third parties that have been engaged directly by the employer, such as architects and structural engineers. And in the unamended form of contract, the contractor is not responsible for any design contained in those employer's requirements, but this is often amended so that they are also responsible for that design. And as such, this then creates a single point of design responsibility under the contract. Therefore, if there are any issues with the design, the employer would only need to seek recourse from the contractor. The JCT forms do not require the contractor to verify the adequacy of the third party's design or the contents of the employer's requirements, so these are generally amended when the contractor is taking on full design responsibility. Under traditional procurement, so for example, a JCT standard building contract, these can either be with or without contractor design. The employer will have engaged a design team and they will remain responsible for that design. So the employer would need to claim against them for any design deficiencies. The contractor can then take responsibility for a part of the design known as the contractor's design portion. This is also an option under the minor works and the intermediate forms of contract. Design liability can be limited under the contract by way of a financial cap. Where it is, this is usually in line with the amount of professional indemnity insurance that the contractor holds. This does not, however, apply to any liability the contractor has to pay liquidated damages. The standard of care in respect of design under the JCT contracts is that they will use the reasonable skill and care in such design to be expected of a qualified and experienced architect or other appropriate professional designer undertaking the design of the work similar in scope and character to those on the project. The standard of care that consultants such as architects are to meet in both contract and tour is reasonable skill and care. as Tim mentioned, and so that's what applies here. But this is again often amended to be all the reasonable skill, care and diligence, which will enhance this standard. Additionally, the 2024 editions of the design and build and the standard contracts also contain a specific provision which means that the contractor will not be subject to any obligation which requires a design to be fit for purpose. This is generally an accepted position within the market and is rarely amended. Over to you, Tim.
So dispute resolution. In the NEC contracts, there are 3 dispute resolution clauses, but the client just selects one. Although it's a choice, the choice gets driven in our domestic context by the Construction Act. And so the Construction Act states that we have to be able to refer a dispute at any time. And that cuts across the drafting where the Act doesn't apply, which would allow the parties to refer something to the representatives before going to adjudication, and sets timescales in which disputes must have been raised. Otherwise, you're barred from raising the dispute. So that the reality in the UK context then is that the dispute process is that you will go to adjudication in the first instance, and that will be an adjudication like any of the under any of the other standard forms, the same sort of statutory timescales, and as we know, those are quite brutal form of dispute resolution, very, very intensive. One party is usually pretty unhappy with the outcome, but the outcome is binding unless you're prepared to take it on to the courts or the tribunal, which could be the arbitrator. But you can't go to the courts or the arbitrator unless you've gone through the adjudication process first. And often a second round of litigation or arbitration where costs are suddenly now on the table as well as the underlying dispute means that often adjudication is the answer, and people stop at that point. Over to you, Natalie.
Thanks, Tim. So I'll just go through this briefly. In order to try and resolve disputes quickly and early, the 2024 JCT contracts provide for the parties to promptly notify the other of any matter that is likely to give rise to a dispute. The parties are then to meet for direct good faith negotiations to try and resolve the matter. Failing that, the parties are to seriously consider mediation, although this is not mandatory. It's important to note that either party is entitled to refer to a dispute to adjudication at any time. The JCT contracts do not have their own mechanism for adjudication, and as such, the scheme for construction contracts applies. That sets out the procedure and timeframes for the process. Arbitration is also provided for under the contracts, but this is often disregarded when amending the contract, as it's usually more applicable to international disputes. And the final resolution process for disputes under JCT is litigation through the courts. Thanks.
So next slide, I think that's Robert.
Thanks, Tim. Yeah, just conscious that we are most of the way through the hour now, I think. So, but as I said at the beginning, what we wanted to do just at the end of this is, having gone through the various different key aspects of the JCT and NECs, just to sort of give a quick flavour of the types of things that we see amended in the various different contracts. So looking at the JCT then, as Natalie sort of mentioned a lot of the way through, quite a lot of the negotiation or the amendments take place as to whether or where the design responsibility sits. If you look at the design and build contract, for example, you know, if the employer is taking responsibility for the employer's requirements, normally what you do is try and flip that on its head, so the contractor effectively takes responsibility for all of the design, whether or not they produced it. So if that brings into play sort of innovation of the architect and structural engineer, if there are any. Quite often see in any context you'll have third-party agreements or project agreements that have obligations on that need to be passed down to the contractor, particularly, for example, where you are dealing with agreements for leases or tenants who need to ensure that the works are done in accordance with the specifications agreed with the landlord. We also look at reducing limitations on liability. As we were sort of saying, that there's in the JCT D&B, for example, there's a financial cap on design liabilities in 2.17.3, which often gets negotiated or struck out. And we'll also look at making sure you have the right sort of obligations in there for workmanship, materials, compliance, etc. Quite often, say for example, if you're the developer on a funded project, the funder may have its own forms of collateral warranty that it would like to be seen, and quite often then you are then amending the building contract to make sure that there's consistency. One of the key points which does get written in, no matter which side you're acting on, is the site conditions. JCT are silent on those issues. It doesn't necessarily mean that the employer takes all the risk for the site conditions, because the contractor has to carry out the work in accordance with the contract and the contract documents. But it is something which does need to get written in. If you are the employer seeking to transfer all site condition risk onto the contractor, you need to have that specifically written in. There are also obligations in terms of the CDM regs. We'll potentially look at the relevant events and relevant matters where they can be tightened up. For example, if it's a statutory provider, has the contractor provided all the information to the statutory provider at the right times that needed to make sure there's no delay to the project? And also looking at building in obligations on the programme. As Tim has mentioned, the programme is extremely important in the NEC, and say, for example, in the JCT D&B, is completely absent. So if you are an employer looking to look at whether or not the contractor is on time, trying to work out whether or not there's serious complications for the project, then you need to make sure that you have obligations on the contractor to provide the right programme. And of course, there's always the obligations in terms of the warranties, amending the copyright license so it's more favourable to the employer, and making sure you can get the third-party rights, etc., to those who need them. And I think finally, the 2024 JCT suite of documents, one of the things they changed was to make reference to the new building regulations and all the changes which have come out of the Building Safety Act. But what we found mainly as a firm is that whilst they refer to specific areas of the legislation, what they don't necessarily do is give the parties particularly good guidance as to when certain actions need to be taken and by whom. For example, if you're a non-high risk building and you're looking at completing and getting the building regulation completion certificate, you need to have the statements from the principal designer, the principal contractor, and eventually the client. So if you're not being kept up to date as a client, you won't know when you necessarily need to give that information, which if you are a client which is based overseas, that's potentially problematic. And of course, generally, JCTs do not deal with higher risk buildings themselves, which we're all getting to grips with. So if you are dealing with a higher risk building, then all those implications of time and money and delays at Gateway 2 and Gateway 3 need to be specifically written in as to who's taking the risk on those. Tim.
So next slide. I'm not going to go through these in detail. We can pick these up in later events, but really to echo some of what Robert has said is that certainly the statutory context around Building Safety Act and high risk buildings is something which that the contract doesn't deal with in terms of contract conditions. The contract's often used in a public sector context too, so there's often drafting which has to deal with the obligations which public sector have and bring in certain of those things around things like freedom of information, those kinds of issues. And there will just be the usual commercial negotiation around where risk sits. So that's all could be dealt with on another day.
Thank you, Tim. Just quickly then, I just saw, I appreciate that the hour is up now. Had a quick question in on JCT homeowner contract. Does that qualify as a construction contract under the rules of the scheme? It's homeowners. The JCT homeowner contract is designed for residential occupiers, so therefore the scheme won't apply. But what it does do, I believe, is have an option for adjudication, which you can choose to use if you wish to. Although as a firm, like Owen Mitchell, we do have a quarter protection team, so sometimes we are involved in advising residential occupiers for buildings which need to be specifically adapted for people, and we quite often advise not to take adjudication as an option for those types of contracts, because the employer or the owner of the building is not often well equipped to sort of deal with an adjudication. So that was one question that came in, and we had a pre-submitted question, one for you, Tim, just quickly then. How popular has the NEC 4 been against the NEC 3 in recent projects?
So the NEC 4 now has been with us since 2017. It is a definite improvement on the NEC 3. So for those people who've come out of their legacy contracts and now procuring, they are generally procuring on NEC 4 contracts, but that there are a lot of frameworks which still got contracts being let under NEC 3. So both are still very present in the market, but most people move to NEC 4 once they get the chance.
Great. Thank you, Tim. So yes, that's it, I think, for today. If you do have any more questions, please feel free to submit them to them afterwards. The QR code is there on the screen for information on the rest of the seminar series. I'd like to thank you very much, Tim and Natalie, for today. And as I say, hopefully we'll see you on some of these more in the future. Particularly look out for the ones which we're holding face to face, and we'll see as many of you as we can there. So thank you very much, and enjoy the rest of the day.